Hi, I'm Janice Switlo, and today I'm going to share with you excerpts from an article written in 2011 by an author of the name of Karen Engels. I actually posted this earlier on my Facebook on a public post. So if you want to have access to these quotes in writing, that's where it is. And her article is titled "On Fragile Architecture, the UN Declaration on the Rights of Indigenous Peoples." Now, I have made it very clear that probably in Canada I'm the only academic, if you will, or Indigenous rights proponent who did not sign that petition that was sent out to try to get Canada to endorse UNDRIP. That is because for many years previous I have warned about what that thing was about, how Section 35 doctrine, domestic doctrine, was the pilot project that Pierre Elliott Trudeau, when he was Prime Minister, put into place. And UNDRIP is simply the template to show other UN member nation states how to implement and put in place a corresponding Section 35 equivalent in their constitutions. And many have done that, for instance, Brazil, and people are seeing the effects of their relying on their Section 35 domestic doctrine equivalent. It's being used against Indigenous nations and Indigenous peoples. But I'll save for now my discussion on those kinds of details, but just to let you know, I have a long history of warning about UNDRIP. So it was, as I was researching something else, I came across this article that I did not see at the time. As I said, this was back in 2011. But, it's nice to know there's other academics who understand exactly what UNDRIP is and isn't. So I'm just going to proceed and kind of read through this for you. Remember, in this, the treaties between Indigenous nations and the Crown are actual law, and UNDRIP is just a declaration. As I said, it's a template. But if there are no more treaties, because the nations fall or are abandoned, and with that failure, the treaties also fall, or through the various agreements that Canada and the provinces, especially that don't have treaties in place, are very keen on getting UNDRIP as a foundation to complement their Section 35 doctrine, then, if the nations no longer exist, the treaties fail, then, you're left with domestic ethnic minority, status, which I've warned about, leaving you only to beg. And so, what this article sets out is that, with cultural rights don't amount to human rights is the direction that UNDRIP is going. So that means, there's no human right to hold a powwow, for instance. Section 35 rights work well with incorporated entities that have no human rights. Remember, an incorporation has no human rights. Because cultural rights are not human rights, so land claims, self-government agreements all work well with Section 35 and UNDRIP, and that's why those agreements that are being pushed, specifically I'll say they're under Section 35. But Section 35 and UNDRIP are clearly the enemies of nations and treaties. And I talk about, I wish that people who were involved knew more than they did, or weren't. It tends to be this thing, people jump on something that's current, a fad, but they may not necessarily really know the issues. They just jump on and parrot things and have fun with it. And so I said I agree with the author's statement. As Karen Engels said, quote, "I would contend and have argued in detail elsewhere that advocates have often aided in the production of Indigenous subjectivities that are limited in terms of whom they actually cover and in terms of what they permit. Perhaps most importantly, however, Indigenous rights advocates have often not been very successful in terms of gaining the recognition of rights that are in real tension with liberal individual rights. That is, the former is nearly always subordinated to the latter. So I am not, as I said, I'm not the only academic warning this. She says further, quote, embedded in it, UNDRIP, are serious limitations to the very rights it is praised for containing. In reviewing, she goes through earlier work in the field. She says, in other words, the victories have brought with them, often unintended, limitations and downsides, which I have largely pinned on the reification of Indigenous culture alongside the rejection of self-determination claims and the acceptance of a cultural rights framework by international institutions. This right to culture, sometimes for individuals and sometimes for groups, fits quite comfortably with and was perhaps even facilitated by neoliberal development models. Now, if you look at these self-government agreements Canada's pushing, you'll see cultural everywhere, right? Because that all fits within this goal, this tactic, right? UNDRIP, quote, represents the continued power and persistence of an international human rights paradigm that eschews strong forms of Indigenous self-determination and privileges individual civil and political rights. In this sense, I contend that UNDRIP signifies continued limitation of human rights and the perpetuation of certain biases, including the suggestion that cultural rights, particularly in their collective form, are outside the domain of human rights. So, that cultural genocide, that is clearly outside of human genocide. So that's why the former Supreme Court of Canada Justice was comfortable saying cultural genocide, because she's not talking about humans when she's talking about cultural genocide as this doctrine or this strategy goes. Quote, I will argue that while the Declaration has made significant strides in the areas of the protection of cultural heritage, land rights and development, it does so in ways that are potentially undermined by its end-of-the-day commitment to state sovereignty and to an especially individualistic and liberal form of human rights. The passage and interpretation of the UNDRIP provides an opportunity for advocates to consider anew the structural biases and blind spots that have motivated Indigenous peoples' demands. And, this is that, seeing what they want to see instead of being able to objectively review and conduct some good legal analysis, which, I have done, right? I can see without those biases. I don't, it's hard when people have been oppressed for so long to not read into something what they want to see, that they desperately have tried to get. They want to see that it's there. And of course, good legal drafting can suggest things are there when they really are not. You have to look at the whole document. And you have to be a really good, you have a good legal eye. Quote, the Declaration seals the deal. External forms of self-determination are off the table for Indigenous peoples. That means even though Indigenous nations, vis-a-vis Canada, have treaties that confirm and recognize their Indigenous nation's sovereignty by coming under Section 35 and endorsing UNDRIP as being the way things should be, they're giving up their sovereignty. Fortunately, the decision for that rests in the people and the Indigenous nationals as a whole, not those self-selected who were consulted at the UN Permanent Forum on these issues. Quote, the assertion of such static views and desires of Indigenous peoples, as I demonstrate in Section 2, betrays much of the history of Indigenous movements. In other words, this is not what the ancestors were seeking. This is not how they spoke about who they are and what they have, and what was needed in order to obtain justice and fairness in the world. That's not UNDRIP. In quote, Indigenous rights are thus defined explicitly or implicitly with what the literature on colonial law refers to as the Repugnancy Clause. As Leon Shelliff explains, this clause was not presented merely or even mainly as being some sort of compromise between conflicting value systems and their normative rulings, but as being an expression of minimum standards being applied as a qualification to the toleration being accorded to the basically unacceptable norms of backward communities. You know, doctrine of discovery all over again, right? Quote, paragraphs sub 2 and sub 3 of Article 46 of the UNDRIP, as I suggested in Section 1, threaten to function in the same way as the Repugnancy Clause that I've just quoted, by subjecting the rights contained in the Declaration to the vague standards of, quote, international human rights obligations and justice, democracy, respect for human rights, equality, non-discrimination, good governance, and good faith. The provisions offer states a way to define certain Indigenous claims out of these categories and to deny them accordingly. And she concludes, you know, recall Harold Laski's 1947 statement that, and this is when you're talking about the Declaration on Human Rights at the time, it would be better to have no declaration than one that was half-hearted and lacking in precision, or one which sought an uneasy compromise between irreconcilable principles of social action. Might we also apply Laski's words to the UNDRIP, this author says. She says, I have indeed attempted to suggest that has reached an uneasy compromise between irreconcilable principles of social action. I also hope I have shown that the UNDRIP does not definitively resolve, but at best temporarily mediates multiple tensions. So, building upon doctrine of discovery, exactly as because Section 35 is built upon doctrine of discovery, and Section 35, as I repeat ad nauseum, is the pilot project. This is why Trudeau Sr. was so popular in the world, because he had devised a way to do in with everyone's Indian problem. You know, and that's all I have to say.